Good morning, and thank you for joining us for this morning's hearing, Righting the Enduring Wrongs of the Holocaust, Insurance Accountability and Rail Justice. I want to recognize Mr. Herbert Carliner, who was scheduled to testify at our hearing this morning, but he was injured while attending last week's Kristallnacht ceremony, Mr. Carliner's testimony will be submitted for the record without objection, and we wish him a speedy recovery. It pains me to say that survivors of one of the greatest atrocities of the 20th century continue to feel the pain of the Nazis' brutality and oppression. These lingering injustices stem from those who sought to profit from the abuse of innocent victims and took advantage of circumstances to enrich themselves while others suffered. This morning, we will be discussing two situations linked by a common theme: the rights of Holocaust survivors as American citizens to bring legal action in federal court. The first is the issue of unpaid Holocaust-era insurance policies. In pre-war Europe, hundreds of thousands of individuals who would eventually be victims of Nazis' crimes sought to protect their families' futures by purchasing insurance policies. However, when the Nazis raided their homes and deported them to ghettos and concentration camps, documentation of their insurance policies was lost. Those who survived the war approached the insurance companies, expecting the companies' records to validate their claims and allow them access to the funds they were owed. Instead, they were turned away for lacking proper documentation and barred from accessing the company's records. The insurance companies refused to honor policies without documentation that they alone possessed and refused to disclose to claimants. In other cases, survivors made claims on insurance policies belonging to relatives murdered by the Nazis, only to be told that their claim could not be honored without a death certificate. Can you imagine anything more outrageous than asking for a death certificate for someone murdered in Auschwitz? In 1998, the International Commission on Holocaust-era Insurance Claim, ICHEC, was established to resolve these issues. However, ICHEC suffered numerous flaws, including problems with accountability and oversight, stemming from the fact that the process was greatly controlled by the insurance companies. 84%, 70,000 of the 90,000 claims made were rejected. 84%, 70,000 of the 90,000 claims made were rejected. 34,000 were offered a token humanitarian award, cold comfort in the face of the broader dismissal by ICHEC. Worst of all, survivors were told that this was the only forum in which they could make claims. So ICHEC sought to limit the rights and access of Holocaust victims, even though several states had passed laws enabling survivors to pursue legal action against these insurance companies since they had been summarily dismissed by ICHEC. These survivors deserve the opportunity to have their day in court and present evidence against these companies who have failed to honor their business obligations. Holocaust survivors came here looking for the freedom, tolerance, and opportunity that they were denied in their homelands. We cannot deny these individuals the justice they more than deserve after they have suffered through so much and waited for so long. We cannot allow these companies to continue to profit from the horrors of the Holocaust. The other issue we will be addressing this morning is justice for those who were transported to concentration camps by the French rail company SNCF. SNCF operated trains for profit that transported over 75 victims to primarily Jews, but also American POWs, to Nazi concentration camps. These trains were run as commercial transactions. SNCF was paid per passenger, per kilometer by the Nazis to move them to their deaths. The conditions in the trains were horrible. Passengers were forced to stand with virtually no food or water or without sanitary facilities. And SNCF knew exactly how bad these conditions were because their employees cleaned the cars after they reached their destinations, removing the corpses of innocent victims who died during the journey. SNCF has not denied its wartime activities. Its officials claim that they were forced to do the things they did. That sounds familiar. And yet SNCF has not contributed to post-war reparations to victims of the brutality of the Nazis. And when Holocaust survivors in the United States brought a class action suit against this company, SNCF, the rail company, hit again. This time behind the Foreign Sovereignty Immunity Clause, claiming that SCNF is an instrument of the French government and should not be held liable. Notably, SNCF has used the opposite defense in French court, claiming to be performing private functions rather than government work. They can't have